Good afternoon, ladies and gentlemen, and welcome back to the 8th International Conference on the Law of the Sea. Now, we shall begin session 4 under the topic of capacity building and transfer of marine technology. And this time, Her Excellency Kathy Ann Brown, the judge at the International Tribunal for the Law of the Sea, will moderate this session. So Judge Brown, please, the floor is yours.
Thank you very much. You will notice our distinguished panel, and you will see a feature that you have not perhaps noticed in previous panels. This is an all-woman power show. Okay, this is unique for this conference. In our introductory session, you will recall that congratulations were given and many thanks to Korea for the key role it plays in capacity building. And so I think that is very fitting that we're here having this session in Korea. And so we want to thank our distinguished hosts for their generosity and their continued commitment to having this workshop. We also heard in the first session that there were only 10 countries that can fund ABNJ research. And I think that underscores why this session is so important for the remainder of the world that doesn't have the financing and the capacity to really get engaged at a meaningful level. So our first speaker is Ms. Soto. Ms. Soto currently works as a legal counselor at the Permanent Mission of El Salvador to the United Nations in New York. Her portfolio includes matters related to oceans and the law of the sea negotiations, among many other things. And in terms of key issues for this particular session, she was facilitator for the discussions on capacity building and the transfer of marine technology at the request of Ambassador Lee of Singapore. And I also think it's very important for this session in terms of her distinguished career, because this session is noting of the rule of law, the importance of the rule of law. And Ms. Soto previously served as rapporteur for the Special Committee on the Charter of the United Nations and on the strengthening of the role of the organization in 2022, and part of the co-chair's team in the revitalization of the work of the General Assembly process since 2020 until 2023. And the last aspect of her distinguished career, which you can find in the booklet that I will highlight, is that she is also served as a professor of public international law and Central American integration law at the Jesuit University in El Salvador. So Ms. Soto, the floor is yours.
Good afternoon. 만나서 반갑습니다. Thank you very much for all your support and providing us this opportunity to have a fruitful exchange in this important conference. And with regards to capacity building and the transfer of marine technology, that is indeed one of the key pillars of the agreement that will ensure the ability of each party to fully implement the obligations therein. And there's a new Uruguayan singer that's called Jorge Drexler, and he tends to say in his concerts that languages are bridges. So with these very few words, I would only like to express our bridge to you, but also your bridge to us, in order to see how can we have a more fruitful exchange of views of this chapter, but also a very important exchange of different points of view that could also complement and see what the challenges are ahead in order to fully implement this particular part of the agreement. Just as to set the scene, well, previous speakers have always pointed out that BBNJ is one of the most perfect examples of how a harmonized ocean governments can be focused on the protection of marine biodiversity beyond areas of national jurisdiction. And indeed, CBTMT will ensure the possibility for all parties, particularly developing states parties, to fully implement obligations set out therein. Capacity building in BBNJ had the purpose to fill in the legal gaps or voids that in UNCLOS the provisions could have shown. So we had the particular challenge to go beyond UNCLOS and further ensure that capacity building could be an effective, iterative process, but mostly a country-driven process that is responsive to the needs and interests of parties. So having this purpose in mind, what I intend to do with this presentation today is to provide you with an overview on how negotiations carried along. Being a facilitator is not easy because I think one of the first personal commitments that you have to understand as a facilitator is to give up to your position that you have constantly defended throughout the whole process. And I think for me, that was a particular challenge. I come from the core Latin American group of countries, and capacity building was indeed one of the main topics that I had to negotiate and as a leading negotiator. And I think by being a facilitator, it provided me the opportunity to also see in an overview all the positions that delegations had to express during the process. So what I'll aim to do in this presentation is to provide you with the key elements that helped us to reach towards consensus. In this regard, having also included the key elements, we will then just picture a main conclusion on what are the steps ahead for capacity building, the main understanding of the points of compromises that were made in this particular part of the agreement, and the important role that relevant stakeholders also played during the negotiations. So what are the key elements? First of all, I have namely pointed out 4. I'm pretty sure I'm leaving a lot of space to Q&A section for also further go into comments, but the 4 key elements that we had to address during the 5th resume session was the definition. Why was it necessary to have a definition on capacity building? And also the definition of marine technology. Would the definition of marine technology include or not the reference to related biotechnology? So those were the main aspects that were discussed during the definition. The nature of obligation. And finally, to progress from that dichotomy that we used to have on mandatory, voluntary, with slowly stepping into a notion of trying to distinct capacity building from transfer for the marine technology. The third key element is the additional modalities, which was the point of compromise. It was a significant step ahead, but also a significant compromise from all parties that were negotiating. And the fourth element is monitoring and review mechanism. How will be ensuring sustainability for the implementation of this part of the agreement? I will go further into depth in each of these elements. This is just an overview on the ones that have been pointed out. So let's start with the need for a definition. So why is a definition so important? And this might come to you as a very blunt question. We need definitions to arrive to a common understanding. And having said that, like for example, we are dealing with an agreement, an international legally binding instrument that it is very important for all parties to have a common understanding on what the use of terms and the scope and the sense of these terms represent. So the Core Latin American Group initiated this proposal of having a definition in the agreement. And I remember in the 4th Intergovernmental Conference, there was a lot of references, conceptual references even, on monetary and non-monetary benefits included in the definition. So it was a bit wary definition because we had to really achieve a common understanding that could bring all parties into the table. And in that sense, during the 5th resume session, there was a shift of position from the Core Latin American Group on this definition particularly, because the question to answer during the 5th resume session was, which is the framework that parties shall resort to have language for a definition on capacity building? Because we have many different definitions, processes, it's a horizontal process, but what could be a definition that could really bring us in a middle ground? So parties from the Core Latin American Group and also delegations throughout negotiations reached an understanding to resort to Chapter 37 of Agenda 21. Agenda 21 was adopted in the United Nations Conference on Environment and Development, held in Rio de Janeiro, and in June 1992 by more than 178 governments. And I think one of the important elements from this definition that is provided in Agenda 21 is that it referred the multi-dimensional nature of capacity building. Capacity building is not only referred to know-how or how to transfer knowledge. It's not only a process of transferring knowledge, it's also a process of enhancing capabilities from each of the dimensions that you can see in the slide. We have the human dimension, institutional and organizational resources. Also, we have the financial management, which I will later explain the sense of this term and scope. But also we have the scientific and institutional and technological capabilities. So all of these together, and if we are aiming to provide a definition, then all of these elements had to comprise the conceptual understanding on capacity building. Capacity building itself. What does it mean when it refers to financial management and other resource capabilities? So there we had a very long discussion in the informal consultations. The financial management, before the initial proposal, was financial capabilities. And what it meant the purpose of the proposal was to have a linkage between capacity building and also the funding mechanism. But throughout the negotiations, parties really understood that it was important to better yet define how the capacity building committee would ensure the function of identifying and mobilizing funds for the programs and projects on capacity building. So as to respond to that understanding, it was better yet suggested, how about financial know-how? But then financial know-how was not like a very universal term, and then one delegation suggested financial management. And that is how we arrived into a financial management a term that is comprised within the definition of capacity building. And as you can see, goes beyond even of Agenda 21, Chapter 37, suggested definition. Another issue that was also discussed with regards to conceptual manner of capacity building was the placement. So before, we wanted to ensure the definition within the use of terms, but later on, a point of compromise was to include it in paragraph 1 of Article 44, current Article 44, as to provide a general understanding on the types of capacity building. So there we have a common ground, conceptual common ground, and another important common ground that we had to arrive to was the marine technology definition. But particularly, and I would like to refer here, the inclusion of related biotechnology. So one of the important packages that were under discussion was the fact that if we were to provide or define even the nature of the obligation for the transfer for marine technology, then we had to, one delegation, one regional group, decided to suggest the fact that we shall always refer to biotechnology. And that was within the additional modalities. But there were certain reservations from other group of delegations, and I think a way of compromising the positions was, how about we include related biotechnology within the definition provided in the use of terms? And that is how we ended up by adding just a small caveat, related biotechnology. But it certainly helped to move forward the discussions regarding the nature of the obligation. So with regards to the nature of the obligation, and this was, I think, capacity building and transfer of marine technology has two core provisions: the nature of the obligation and additional modalities. The nature of the obligation provides you with the action verb. Was it shall ensure? Is it shall cooperate? Is it which verb shall we arrive to? And the additional modalities, they provide better understanding on whether it is under mutually agreed terms or conditions or fair and reasonable terms, but also it provides you an overview on how the legitimate interests of duties and rights of holders could be balanced or managed or respected vis-a-vis the interests and priorities of developing states parties. So that's why I think these two provisions and the compromises that were made in these two articles were important to arrive to a definite position into the whole agreement. So let's start by the nature of the obligation. And this is where finally, after having dichotomy on mandatory, voluntary, parties managed to understand that we had to distinguish between capacity building and transfer of marine technology. Each of these would have a different type of obligation, a different nature of obligation. But to arrive to this action verb, like for example, is it shall ensure capacity building, and now as it currently is set out in the agreement, shall cooperate to achieve the transfer of marine technology. To arrive to that discussion, to that conclusion, we had to first discuss the additional modalities of the agreement. But also one of the important things that were also referred to, and this was, let me check, it was Article 44, if I'm not if 42. It was also to understand the caveat on within their capabilities. That was another point of compromise. So Article 42, paragraph 1 reads, parties within their capabilities shall ensure capacity building for developing states parties and shall cooperate to achieve the transfer of marine technology. The caveat on the within their capabilities, it was an understanding from delegations that if we were going to refer only parties, we shall resign to the fact of distinguishing developed and developing parties. It was an understanding that if we were referring to parties all equally, we were going to abide by the obligations provided in paragraph 1. So that was a huge compromise because in the end, a large group of regional regional group consisting or comprising with large delegations decided to see the caveat and leave the caveat within their capabilities. Parties, all equally under an equal standing, shall ensure capacity building, and that was a common consensual definition because we did understand that capacity building was the most important element. But for the transfer of marine technology, we had to take into account, before defining the action verb, we had to take into account how the legitimate interests and intellectual property rights were going to be respected in consideration or with respect to the interest of developing states parties. So that was an important also point of compromise. Stepping ahead to the additional modalities, which was the most important compromise that was made. So the main concern here in this discussions, I don't know if, well, delegations might remember that time that we even had in screen like 4 proposals, very long proposals on the additional modalities, and we were reaching towards the final deadline of providing an outcome to Madam President and, at the intergovernmental process. And in the end, we had to reach to an understanding that the main interest from developed partners, as to put, was to protect the patents of the new technology. For example, if a new technology is put into the market and the private sector gives or provides a very substantial support to that technology. So the patents from that new technology just put into the market was the one that would have to be under cooperative modalities. Whereas the technology that is on the current use of the market, there was a delegation that used to express the term off-the-shelf technology, then the patent of that technology could be under a more stronger or binding language. Understanding this tier approach, this division between off-the-shelf technology or the new technology just put in the market, really helped delegations to understand why was it so important to leave the language or to start off the language on the legitimate interests and the protections of rights and duties from holders with respect to the interests of states parties. And in this regard, for example, in Article 43, paragraph 4, you will see that we resigned the idea of linking a specific reference to the legal instrument, for example, the TRIPS agreement, because delegations were not comfortable on binding on a specific instrument, but just rather live in a general manner. And this was also something, the text that Madam President Ambassador Lee provided at the end of IGC4, just to leave the transfer of marine technology shall take into account all rights over such technologies and be carried out with due regard for all legitimate interests, including inter alia, the rights and duties of holders, suppliers, and recipients. So the counterbalance to that paragraph was to add, taking into particular consideration the interests and needs of developing states for the attainment of the objectives of this agreement. And this, even if the developing parties knew this was a point of compromise, but even this represents a step ahead, because usually the modalities on transfer for technology in other processes, intergovernmental processes, for example, ocean law of the sea, they are only referred into the mutually agreed terms or voluntary character of the obligation. But here, we were acknowledging the rights of holders and recipients, but also we were acknowledging the needs of developing states parties. So that was the perfect counterbalance that later on helped delegations to further get into discussions into paragraph 2. Paragraph 2 of Article 43, so here the balances, that I was talking to you about, the protections of patents and IPRs with regards to development. So it's basically intellectual property rights vis-a-vis development. So, but when reaching to the different proposals on additional modalities, so we had basically 3 proposals. I did not want to bring all the scenarios that we had been discussing, but basically the alternative 0 proposal was the one that drew language from important instruments such as Article 16 of CBD, Convention of Biodiversity, and also Annex 2, letter F from Nagoya Protocol. So in this proposal, we entail all the modalities of transfer of technology, meaning mutually agreed terms and conditions, but also the fair and most concessional and preferential terms in accordance with mutually agreed terms and conditions. So this proposal, these modalities, would be already counterbalanced by the agreement that we reached in paragraph 4 of Article 43. And then the rest of the proposals were drawing the opposites of the discussion. So, for example, one proposal was making an emphasis on fair and most reasonable terms, which is more oriented into developing parties, but also another proposal, alternative 2, was more oriented into the protection of these types of technologies, different types of technologies, and the protection of patents. So in order to have a middle ground, alternative 0 proposal was, as one representative bluntly put it, this is a constructive ambiguity. It's like here, we are equally, could be happy or unhappy, but this was the middle ground delegations reached to after having all discussions, but also drawing language from CBD and Nagoya Protocol. On Article 43.1, you might read a vision statement. Since developing parties already were comprising into this solution, they decided to put a paragraph that would be sort of like a vision statement. So share a long-term vision of importance, fully realizing technology development and transfer for inclusive, equitable, and effective cooperation and participation in the activities undertaken in this agreement. And that was the counterbalance for developing parties that later on helped to reach a conclusion on the action verbs. So basically, by compromising in additional modalities and understanding the needs from each positions, we reached a solution in the definition of the nature of the obligation. We managed to finally decide that capacity building shall be ensured, and that the transfer of marine technology shall cooperate to achieve. And that is under the understanding of the additional modalities. So, with regards monitoring and review, capacity building committee was indeed a huge step forward also from developing parties to the negotiations. We understood the nature of the obligation. We had already agreed on the additional modalities, but we needed an institutional framework that could, in the future, further enhance a full implementation of this part of the agreement. And in this regard, the CBTMT committee, one of the first things that it draw consensus from everyone is the gender balance and equitable geographical representation, but also the definition on the composition, which is in paragraph 2. It was with regards the expertise that shall be required to be part of this capacity building committee. And the terms of reference was, in a way, the goodwill of parties to leave it to the conference of parties to decide how these terms of reference would be. Also, my sense as a facilitator is that delegations did not want to reach a fast decision, considering that we were really fast approaching the deadline, and to get into discussions on the terms of reference would entail longer time. And I think that was a very pragmatic solution, but to recognize this is one of the steps ahead and challenges that we have ahead of a capacity building committee. And another substantial achievement within the CBTMT committee was to make that linkage with the financial mechanism. When it refers to the function of the committee to identify and mobilize funds, then parties managed to create a linkage with the funding mechanism as to ensure its sustainability. And well, as a conclusion of capacity building, CBTMT, as we use acronyms, I am not much of a fan of acronyms, but one that gets pulled into these negotiations and in the UN tends to get used to the use of acronyms. But what's the main conclusion? In CBTMT chapter, parties really reach to the definition of the nature of the obligation thanks to the true understanding on additional modalities. So the point of compromise was the additional modalities that really paved the way through the nature of the obligations. And also, it is important to understand the distinction that parties agreed to with regards capacity building and TMT, that as two different but related concepts that would really ensure the full implementation of the agreement. Or most importantly, also the interrelation of this part with the EIAs and also MGR section, which would surely operationalize the objectives set out in the agreement in Article 42. But lastly, the importance and the valuable support from academia and all relevant stakeholders. Myself, I witnessed the added value that academia provided to me. Being a facilitator, having no background on biotechnology, I needed someone, an expert, to explain to me what is biotechnology, why was it so important to include it, and what could be the different scenarios that we could take onto the table, and finally reach a conclusion on the agreement. So definitely the support of relevant stakeholders and academia will be most importantly to keep carrying out the implementation of the agreement, to keep socializing this agreement to all parties, even developing states parties, and reach a common understanding on the obligations that are comprised in the text. So with that, to reiterate once again my huge appreciation to the organizers of this conference, and I am more than happy to give the floor back to the moderator and my fellow co-panelists that I'm pretty sure they will, from their perspective, complement this presentation. Thank you so much.
Well, we really have to thank Ms. Soto for her presentation, which gives us insight into the negotiating process. And it made me think of the great commentaries we have on UNCLOS. Don't you think we need an equally great commentary in the future on the BBNJ negotiation, the agreement? And I think that the facilitators should get involved in that. So we're looking forward to you assisting in that process, Ms. Soto.